Mr. President, members of the court, good afternoon. I will respond to Myanmar's attempt to challenge the determination by the UN fact-finding mission, corroborated by many others, that Myanmar exhibited a pattern of conduct that can only be understood to reflect its intention to destroy the Rohingya as a group in northern Rakhine State. In so doing, I will take stock of the evidence and arguments, including the witness evidence, that go to the question of Myanmar's pattern of conduct. I begin with the requirements. As the court held in Croatia v. Serbia, a pattern of conduct simply requires a consistent series of acts carried out over a specific period of time. A pattern of conduct can thus be established, for instance, where widespread attacks are carried out according to a generally similar modus operandi. In the Croatia case, such a pattern was found to exist because there is evidence that widespread attacks by the JNA and Serb forces on localities with Croat populations in various parts of Croatia were carried out according to a generally similar modus operandi. Myanmar has sought to argue that establishing a pattern of conduct requires the court to engage in a minute examination of every instance where Myanmar is alleged to have committed an act that forms part of the general pattern, and that in each place, precisely the same order and types of events need to be established. You heard this during Ms. Lowry's presentation, in which she went village by village, which tried to call into question the evidence obtained by the fact-finding mission and others in regards to those villages. Mr. Reichler has already shown why the evidence is reliable, credible, and trustworthy. But Myanmar's approach is misconceived for an even more fundamental reason. As the court explained in the Bosnia case, it need only consider the facts alleged in the light of the question whether there is persuasive and consistent evidence for a pattern of atrocities which would constitute evidence of dolus specialis. And for this purpose, it is not necessary to examine every single incident reported by the applicant, nor is it necessary to make an exhaustive list of the allegations. In other words, no Myanmar-style audit is needed. Instead, it is sufficient for the court to examine those facts that would illuminate the question of intent or illustrate the claim by the applicant of a pattern of acts committed against members of the group, such as to lead to an inference from such pattern of the existence of a specific intent. Myanmar's attempt to suggest that any variation somehow negates the pattern is equally flawed. It does not square with the court's jurisprudence that a generally similar modus operandi is sufficient. The court's approach is plainly correct, and Myanmar presents no cogent reason to depart from it. Inevitably, there will be locations where the available evidence may show greater or lesser levels of killings, sexual violence, or other forms of abuse. All the more so in circumstances where, as is the case here, the available evidence has been affected by efforts to destroy the evidence, and independent investigators are refused access. And of course, inevitably, there will be variation over time and location and how the perpetrators conducted themselves. A pattern of conduct does not require undeviating, identical conduct in all locations and at all times. It simply requires sufficient similarity in the perpetrator's modus operandi to show a broadly common and consistent approach across place and time. Here, there is certainly broad commonality. The totality of the evidence, including Professor Newton's unchallenged expert testimony, corroborates the mission's finding, confirming that the evidence is consistent in showing that Myanmar carried out widespread attacks according to a generally similar modus operandi, and that this modus operandi includes persuasive and consistent evidence for a pattern of atrocities. Specifically, the mission verified the common modus operandi of the clearance operations to exist with respect to at least 54 villages, and received first-hand accounts of an additional clearance operations conducted in a further 22 locations. It is to the particularities of that pattern to which I turn now. I begin with Myanmar's preparatory actions. As the first round made clear, much of the evidence is undisputed. Myanmar concedes it deployed Tatmadaw units to northern Rakhine State prior to the wave of clearance operations that began on the 25th of August, 2017. Ms. Lowry said so expressly. Those deployments included highly trained units, including the 33rd and 99th Light Infantry Divisions, or LIDs, which Myanmar airlifted to northern Rakhine State upon the command of the Army's Commander-in-Chief, which soon thereafter carried out many of the clearance operations. Nor does Myanmar challenge the fact that the Tatmadaw deployed its units to strategic locations in close proximity to Rohingya villages. These are all significant, undisputed facts. The underlying facts with respect to Myanmar's other preparatory acts are likewise conceded. In the first round, Myanmar accepted that it had ordered the removal of fences in Rohingya villages, confiscated the Rohingyas' sharp implements and agricultural tools, and imposed draconian curfews and restrictions on movement. The most Myanmar could do was to try to suggest these were anti-terrorism measures that were not directed at the Rohingya as a group, but applied in a non-discriminatory manner, a point unsupported by and in fact directly contradicted by the evidence before the court. Again, Professor Newton's testimony is instructive. As he explained, bona fide anti-terrorism measures would be selectively targeted against suspected terrorists. They would not be imposed indiscriminately against the group as a whole. With respect to Myanmar's termination of humanitarian assistance in the weeks prior to and at the height of both the 2016 and 2017 clearance operations, Myanmar did not dispute any of the relevant facts, not its refusal to allow the World Food Program to distribute aid, not its termination of other food assistance programs, not the fact that these actions occurred against the backdrop of the World Food Program's warning that much of the Rohingya population faced imminent starvation, not Myanmar's refusal to allow healthcare organizations to continue providing urgently needed assistance. Ms. Lowry could not even bring herself to claim these were anti-terrorism measures. All we heard was unsupported hand-waving about security. But the aid organizations themselves had no concerns about a lack of security preventing their operation, a fact confirmed by Mr. Riley's witness statement. Mr. President, the reality is that the clearance operations were pre-planned. The steps taken to weaken the Rohingya population and put in place Tatmadaw units to attack them on command form part of a consistent pattern across northern Rakhine State. Crucially, the evidence also establishes that when Myanmar launched the clearance operations, their modus operandi involved the indiscriminate targeting of the entire Rohingya population. Despite overwhelming evidence to the contrary, Myanmar nonetheless still insists, with the sole exception of the massacre at Indin, for which there is irrefutable photo documentation, the Tatmadaw engaged in no extrajudicial killings. As Ms. Lowry put it, in relation to the alleged killing of males, save for, in her words, the incident at Indin, Myanmar denies that soldiers engaged in extrajudicial killings. We will see if Myanmar maintains that position in view of Mr. Hooper's acknowledgement of the atrocity at Mingi. Last week, Myanmar tried to suggest that the Gambia lacks evidence for the indiscriminate killing of Rohingya civilians during the 2016 wave. Not true. The OHCHR, discussed by Mr. Reichler, concluded that the security forces deliberately targeted the entire Rohingya population in the area. Those are the words of the report. This fully aligns with the FFM's own conclusion, namely that the 2016 operations were characterized by torture, rape, and sexual assault, killings, and the destruction of homes and mosques. These, the mission found, involved the same tactics and violations that were later seen in 2017. And it accords with the findings of the very Amnesty International report upon which Myanmar places reliance. It reported eyewitnesses who recounted how, in 2016, military personnel attacked Rohingya villagers at random, leading to deaths and injuries, and how soldiers entered their village and fired randomly at men, women, and children, often while they were fleeing in fear. Myanmar's employment of the same modus operandi during the second wave is fully documented, not least by the fact-finding mission and the 3 witnesses who testified last week. Multiple witnesses also reported that the military was shooting madly on everyone they saw and in every direction. The modus operandi included killing civilians while fleeing. The evidence is clear. It happened to witness MS's daughter, just as it happened to the daughter of a survivor from Chien Chong, who recalled that as people were running, they were shooting at them. That is how my daughter died. She was hit fleeing. Medical reports referred to by the fact-finding mission confirm, and I quote, that many patients, including women, children, and the elderly, had bullet entry points from behind, consistent with being shot while fleeing. The record includes examples from many places. Significantly, the shooting of Rohingya refugees who were fleeing was common across different Tatmadaw units, including the 33rd and 99th LIDs that were moved to Rakhine State in the weeks leading to the clearance operations. This happened at Mingi, where the clearance operation was carried out by the 99th. The FMM reported that soldiers opened fire directly at a large number of people fleeing towards the shore. Many were shot. One man reported, I think that everybody from my village was running towards the shore. While I was running, there was a lot of shooting, and I saw many people hit and falling down. And the 99th did so as well at Kyok Pandu. There, the mission determined that it carried out a clearance operation.
Mr. Loewenstein, please slow down a bit. The interpreters are having a problem.
There, the mission determined that it carried out a clearance operation in which fleeing people were shot, injured, or killed. A different unit, the 33rd LID, engaged in a similar pattern of behavior in Chep Pin. The FFM reported that the soldiers conducting the operation there opened fire, shooting at villagers, including those who were fleeing. Much the same occurred in Ko Tang Kok, where the mission found that the 33rd led the operation, shooting into the village and towards people fleeing. This brings me to sexual violence, another part of the modus operandi. Myanmar does not appear to contest that a pattern of sexual violence is indicative of genocidal intent. It expressly accepted that sexual violence can never form part of a legitimate counterterrorism operation. Its only response was to question whether the evidence of sexual violence is sufficient. In that connection, Myanmar sought to argue last week that, as Mr. Blom Cooper put it, the allegations of sexual violence arise predominantly in just 2 villages, Mingi and Chep Pin, and that, in his words, there is no reliable evidence of their widespread character. Mr. Blom Cooper appeared to take umbrage at even the suggestion that the Tatmadaw could have committed sexual violence. Taking on the role of Tatmadaw character witness, he assured you that even isolated incidents of sexual violence would, in his words, run counter to the ethos of the Myanmar Defense Services. That's not even argument. That's just propaganda. I turn now to Judge Charlesworth's question, which asked, is the Gambia able to identify the locations where what it calls the hundreds of instances of sexual violence are alleged to have occurred? In answering, I make clear, as the question recognizes, that there are hundreds of instances of sexual violence, not that they necessarily took place in hundreds of locations. But they certainly occurred in a great many locations, far more than the 2 that Myanmar accepts. Professor Sand's reference to sexual violence as being widespread is a direct quote from the fact-finding mission. The locations of many instances of mass sexual violence can be pinpointed, but we do not claim to have a comprehensive list. So we say, on the basis of the FFM evidence, that sexual violence, including gang rape and sexual mutilation, took place in at least 10 village tracts across the 3 townships of northern Rakhine State during the 2017 clearance operations alone. These 10 separate places were Ka Mong Sek, Mingi, Kianchong, Kyok Pandu, Badakar, Nyat Nyat Chong, Tangbazar, Chinthamar, Gudarping, Mongitong, and Chapin. The FFM also noted that alongside these 10 primary locations where this pattern of conduct undoubtedly occurred, the mission received further credible reports of mass gang rapes in a number of other locations. Some of these other locations are mentioned in Chapter 9 of our memorial and Section 3A of Chapter 7 of our reply. The widespread nature of this pattern is confirmed by the U.S. State Department survey that Mr. Reichler described this morning. No fewer than 45% of the more than 1,000 randomly interviewed respondents have personally witnessed rape or evidence of rape. Indeed, the survey showed that the military and police did not appear to hide the rapes from their peers or from those above them in their chain of command. Rather, rapes were largely public in nature, with many assaults either taking place in public view or with perpetrators leaving evidence of such assaults, including the victims' corpses, which clearly portrayed marks of rape in public view. Such evidence of sexual violence perpetrated in full view of superior officers is compelling evidence that it was part of a modus operandi. Moreover, as the State Department's chart on your screens indicates, such levels of sexual violence occurred throughout northern Rakhine State. Although the precise numbers are unknowable, we know that there was at least hundreds of victims. The FFM cites a figure of 1,834. Médecins Sans Frontières reported having treated 230. That's just one aid organization. That does not include those who received treatment from other organizations. It does not include those who received no treatment at all. And it does not include the women and girls who the Tatmadaw killed or who succumbed to injuries while making their way to Bangladesh. The Physicians for Human Rights survey that Mr. Reichler mentioned noted that healthcare providers reported higher numbers of pregnant women during months that corresponded to the patients having conceived in and around August 2017. In the words of one physician, 9 months after August 2017, there was a huge increase in the birth rate. The implications are obvious. I turn now to another part of the modus operandi, the intentional killing of children. I addressed its legal significance in the first round. Myanmar left it unrebutted. Instead, Myanmar's response was limited to Ms. Lowry's statement that the reference to children in the counter memorial reflected the fact that, as she put it, Rohingya youths included those who in most societies would be counted as children, but are nonetheless found in the rank and file of those confronting the military, thereby putting themselves in the way of harm, and, she said, were indistinguishable from older persons. Mr. President, in the first round, I observed that Médecins Sans Frontières estimates between 734 and 2,109 children under the age of 5 died during the clearance operations or were killed during the flight to Bangladesh. Myanmar made no attempt to challenge those statistics. Not a single one of those deaths can be said to reflect an adolescent who chose to put him or herself in harm's way. Nor can the testimony of the witnesses you heard last week. MN described the death of his 8-year-old nephew, NJ the murder of her 2-year-old son, MS the slaughter of 5 of his children. They were 14, 11, 9, 7, and 3. These murders of children, of innocents, not those lining up to fight government forces, were conducted by separate units of the Tatmadaw, specifically the 33rd Lid in Chapin, the 99th Lid in Mingi, and the 564th Light Infantry Battalion in Mongnu. The reality, Mr. President, is that the record is full of reliable evidence that the killing of young children, including toddlers, infants, even the unborn, formed part of the Tatmadaw's modus operandi in both waves of clearance operations. In that connection, I underscore that the evidence from 2016 is consistent with that from 2017. In other words, they both followed the same modus operandi. That's not surprising. They were closely connected episodes in a broader genocidal program in which the killing of children was central. The PILPG survey included dozens of respondents who recounted brutal attacks against children, including the abduction and disappearances of children, the execution of dozens of children in a single attack, and children being stabbed, slaughtered, dismembered, and beheaded. Respondents recounted babies being smashed against floors and walls, thrown out of windows, thrown into fires, thrown into rivers, thrown up in the air and caught on a sword, or thrown into wells. Many witness statements include accounts of the intentional killing of young children, and many such accounts were obtained by the FFM. To cite but a very few examples, a survivor from Kiep Yo Pin described to the mission seeing the Tatmadaw kill 2 young children who were searching for their mother. The older of the 2, a 6-year-old boy, had his throat cut. The younger, just 4 years old, was stamped to death before the body was thrown into a nearby burning house. Similarly, a 14-year-old boy told the mission how, in Kiep Pandu, he witnessed the Tatmadaw push 10 Rohingya, mainly children, into a house and set it on fire. He believes everyone was killed. The boy recounted one of the children was stabbed when the group tried to leave the house. As you heard last week, Professor Newton has no doubt that each of these features of the clearance operations, the targeting of civilians, including those fleeing, the sexual violence, and the killing of children, was part of the Tatmadaw's modus operandi. None is remotely reconcilable with counterterrorism. Mr. President, this brings me to the next part of the modus operandi, the systematic destruction, often through building, of Rohingya villages. The numbers are effectively undisputed. As I noted during the first round, UNISAT determined that as of the 18th of October 2018, at least 178 Rohingya villages had been totally destroyed by fire, with an additional 214 partially destroyed. Did Myanmar present expert testimony showing that UNISAT was wrong? No, although Mr. Blom-Cooper did opine that he might have identified a few structures that he thinks may have survived. Myanmar also tries to argue that the destruction of these villages somehow doesn't count. Why? Because some destruction may have occurred after the 5th of September 2017, when Myanmar claims to have ceased carrying out anti-terrorism operations. But the truth is, Myanmar did not stop then. Here's what the FFM had to say about the matter. While the government has claimed that clearance operations had ended on the 5th of September, in fact, military engagement continued well into October. This included its efforts to systematically and comprehensively destroy huge swaths of Rohingya villages, as the IIMM documented in its September 2025 report. I reviewed that report with you in detail in the first round. Myanmar had next to nothing to say in response. The most it could muster was to seek to cast doubt as to who is responsible for the program of burning. But the answer is clear and provided in the IIMM report itself, as Mr. Reichler showed you this morning. So too is it found in the December 2017 International Crisis Group report that Mr. Reichler also discussed. Let's be perfectly clear about what the wholesale burning of hundreds of Rohingya villages meant for the Rohingya who had lived in those villages. It was described by the FFM in the following terms. The clearance operations forced hundreds of thousands of Rohingya to flee and walk for days, even weeks, through forests and over mountains to reach Bangladesh. On this journey, many more died or were killed or injured. There was minimum shelter, with people having to sleep in the open, with little food or water. This directly impacted Rohingya mortality. The mission determined the appalling conditions of the journey contributed to the high number of casualties. Hundreds of thousands of Rohingya fled with little or no notice and few, if any, possessions. Many had sustained injuries and needed urgent medical care. Mr. President, those appalling conditions are vividly described in the witness statement of Alex Crawford and Neville Lazarus, television journalists with Sky News, who managed to visit Northern Rakhine State in November 2017. You can find it at Annex 374 of the memorial. The video they made of their visit, cited in their statement, can be watched through the link included in the footnote in the compte rendu. The Rohingya facing such conditions had no illusions that they had any prospect of receiving assistance from the same Tatmadaw who had committed horrific atrocities against them. The FFM found that continuing clearance operations and the presence of large numbers of Tatmadaw soldiers and other security forces made it dangerous to travel on main roads or seek shelter or provisions in other villages. Instead, villagers walked for days or weeks in forest and mountain areas, sleeping in makeshift shelters or in the open during heavy monsoon rains and without sufficient food or water. These dire conditions, the mission found, disproportionately affected the most vulnerable, including children and the elderly. Many persons died and were buried in makeshift graves. Here is how one woman described the situation, an account the mission concluded was typical of many. It took 9 days to reach Bangladesh. On the way, I saw 4 or 5 decapitated heads by the side of the road. One of our group died on the journey, a small boy. One woman gave birth. I had a packet of biscuits with me, but nothing else. It was raining heavily. Everything was burning around us. Mr. President, the Tatmadaw's modus operandi included the specific targeting of Rohingya attempting to traverse this hellscape. The scale is indicated by data collected by Médecins Sans Frontières, indicating that fully 13.4% of violent deaths occurred during the period between displacement from their village and arrival in Bangladesh. To be clear, these were not killings that occurred in the context of village-specific clearance operations. Instead, the FFM determined that Tatmadaw soldiers shot at groups of Rohingya who were en route. This included attacks in villages that had already been burned, where fleeing Rohingya were seeking refuge on their journey, as well as attacks in forested areas or when Rohingya were forced into the open, for example, when crossing rivers. The mission's report is replete with evidence that confirms the ever-present danger that Rohingya faced from the Tatmadaw. A woman from Buthodong Township described to the mission how, after walking for 2 days, she and her group were near a river crossing when soldiers opened fire at people as they were crossing. She saw 2 people shot. Another survivor recounted how he and his family were awaiting a boat to carry them across the river when a group of soldiers and police opened fire at a boat carrying people across, killing 4 of the passengers. And here is what still another survivor told the mission. My grandson, who was 3 years old, died when my daughter-in-law jumped into a river while crossing the canal. The military started shooting at people who were about to cross the river. She was afraid and jumped into the river with her son. The child drowned and we found his body later on. Mr. President, I take this opportunity to present the Gambia's observations in regard to Judge Charles Worth's question that asked Myanmar for its views regarding who is responsible for the 178 Rohingya villages that had been totally destroyed by fire by the 18th of October 2017, and the additional villages that had been partially destroyed by that date, including whether Myanmar considers those villages to have been destroyed by ARSA, and if so, the evidence supporting that contention. In considering Myanmar's forthcoming answer, the Gambia respectfully suggests that the court take into account the witness statement of Jonathan Head, the BBC's Southeast Asia correspondent. As recounted in his witness statement, he was present in Northern Rakhine State in September 2017. Mr. Head provides a detailed account of Myanmar's efforts to falsely portray the Rohingya as having burned their own homes. This was done through the staging of photographs and the enlistment of members of the Hindu community to pose as Rohingya in an attempt to con the journalists into reporting that the Rohingya themselves were responsible. Mr. Head and his fellow journalists saw through the sham. The court can find his statement at Annex 375 of the memorial. The relevant paragraphs are 15 to 19. Mr. President, This concludes my presentation. Thank you for your kind attention. I ask that you invite Mr. Suleiman to the podium.